Right to Information Act, 2005. The Right to Information Act, 2005 repeals the Freedom of Information Act, 2002, which was passed by the previous NDA government. This legislation entitles every citizen to have access to information controlled by public authorities. Under the Act, it is obligatory upon authority to provide information and maintain records consistent with its operational needs. These records would have to be duly catalogued, indexed, and published at such intervals as may be prescribed by the appropriate government or the competent authority. The object of the Act is to promote openness, transparency, and accountability in administration. A person desirous of obtaining information shall make a request in writing or through electronic means to the concerned public information officer specifying the particulars of the information sought by him. Section 6. The Act makes provision for appointment of public information officers. Section 5. According to Section 5, every public authority shall designate as many officers as the central public information officers or the state public information officers in all administrative units or offices under it as may be necessary to provide information to persons seeking information under this Act. Every public information officer shall deal with requests for information and shall render assistance to any person seeking such information. When a request for information is received, the public information officer shall, as expeditiously as possible, and in any case within 30 days either provides the information required on payment of prescribed fee or reject the request for any reasons specified in Sections 8 and 9. But where the information sought for concerns the life and liberty of a person, the same should be provided within 48 hours of the receipt of the request. If the request is rejected, the public information officer shall communicate the person making request reasons for such rejection. Section 8 provides for exemption from disclosure of information relating to certain matters. If a person is aggrieved by a decision of the public information officer, he can prefer an appeal to such authority as may be prescribed. Section 19. Section 20 provides that if a public information officer, without any reasonable cause, refuses to receive an application for information or refuses to furnish information within the time specified under Section 7(1), or mala fidely denies information or destroys information, a penalty of 250 rupees for each day till application is received or information is furnished can be imposed. However, in no case it shall exceed more than 25,000 rupees. The public information officers shall be given a reasonable opportunity before any penalty is imposed on him. Section 23 provides that no suit or application or other proceeding in respect of any order made under this Act shall be called in question in any court otherwise than by way of an appeal under Section 4. This law will certainly strengthen the freedom of press because under the Official Secret Act the authorities usually denied the information relating to government documents. The freedom of information is basically a citizen's right, but the freedom of press is not different than a citizen's right. It is the press which discloses the matters relating to public importance and strengthens democracy.